Since our last Crammer, in other words in the last 12 months, the Supreme Court of Appeal handed down 4 judgments concerning trademarks. And I'm going to do my utmost to provide you with a useful executive summary, perhaps a triple distilled summary, if you will, due to the time constraints of these 4 cases. So let's get right into it. The first case is the Clearview matter. This matter has received quite a lot of attention, but mostly on a different level. As you may know, the main fight in the case was about whether it is lawful to register your competitors' trademarks as AdWords. And that's not what this latest judgment was about. This was a sub-skirmish to do with the registration and specifically endorsements. So you might remember that the main fight was based on common law, on passing off and unlawful competition, because Coughlin Steel did not have registrations. Why not? These applications for registration were opposed. So the question that came before the High Court and then also before the SCA was what disclaimers or admissions, endorsements in other words, should be entered against the registration for the Clearview trademark. So the applications for registration were opposed, and as an alternative there was a suggestion that the rights should be limited in terms of appropriate endorsements. So firstly, is there a difference between a disclaimer and an admission? Absolutely. What is a disclaimer? It's an endorsement stating that the trademark proprietor does not own exclusive rights in relation to an element or feature of the mark. Simple example, my trademark is Bob's Burgers. I cannot get rights in burgers. And what is the effect of a disclaimer is the proprietor cannot sue for infringement in respect of use of the disclaimed feature. That's an absolute limitation on the rights acquired through registration. What is an admission? It's also an endorsement, but it states that other parties are entitled to make bona fide descriptive use of an ordinary descriptive word where the trademark is or contains a deliberate misspelling of the word. Now this is something that's unique to South Africa. You don't find admissions anywhere else in the world, so we're quite proud of them. The registrar loves them. But the first question is, are admissions even necessary? And I'm asking the question with reference to section 34(2)(b) of the Trademarks Act. I think many of you will know of the defense to infringement. If you use a trademark in a bona fide descriptive sense, then that does not amount to infringement. So the question is, do we even need admissions? But they do provide clarity, they can't do any harm, and we have them and our registrar likes them. Mm-hmm. So in the Clearview case, the High Court, and also subject to a very small, insignificant amendment, the SCA ordered that the Clearview trademark proceeds to registration subject to 2 endorsements. The first one, a disclaimer stating the registration of this mark shall give no right to the exclusive use of the word clear and view separately and apart from the mark. Now this looks on the face of it like a run-of-the-mill disclaimer. It's slightly strange for 2 reasons. Normally, and this sounds like a very technical distinction, it will say use of the words clear and view, but maybe that's not significant. And of course, view in the normal spelling does not appear in the trademark. So it's unusual to disclaim something that doesn't form part of the mark, but be that as it may, the consequence is any rights that Coughlin Steel may have lies in the combination and not in the separate words clear and view. And also an admission was entered saying the registration of this mark shall not debar others from the bona fide descriptive use in the course of trade of the words clear view and view. So what's the consequence of that? Firstly, the court referred with approval to a principle stated in Webster and Page, which is sort of the leading authority on trademark law in South Africa, that the phonetic equivalent of a non-distinctive word is itself non-distinctive. And that is not true, at least not under all circumstances. Let me give you an example. You will all know the trademark shatterproof, PRUFE for windshields. So according to this principle, nobody can get rights in it. It's not so. Under certain circumstances, maybe so. So the court adopted this principle but didn't really apply it going forward. Because if this principle is adopted and applied, then no right should be afforded in VU. And that's not what the court did. So the next question is, may other traders now use VU? No. Although the SCA didn't deal with this, the Court of Quo specifically considered and refused to enter any disclaimer or admission in respect of VU. And you saw what the wording of the disclaimer and the admission imposed by the SCA. So in short, no, competitors may not use VU. Of course, you must still look at the two competing marks globally. And then the question is, may other traders now use Clearview or Clearview? And now that, in terms of the admission, depends on the way in which these words are used. If they are used purely descriptively, then absolutely, traders may use it, competitors may use it. It's difficult to see how they can use Clearview one word descriptively. That's not the bona fide way in which the descriptive term would appear. But certainly, if it's descriptive, if used descriptively, in other words, not as a trademark, that's perfectly allowable. Right, moving on to the next case, the Pepperdew case. Quite an interesting matter, also concerning an opposition. This was the third court that considered the same facts. It came from an opposition. The registrar referred to the High Court. The proprietor of the Pepperdew trademark. Let me show you what it looks like. The one on the left, Pepperdew, I think many of you know the trademark, quite well known, tried to prevent pepper mates from proceeding to registration. So the High Court allowed the opposition. An appeal was brought before the full bench of the Gauteng division, which confirmed the High Court's ruling, and then on further appeal to the SCA, it was overturned. So let's just see how the parties argued this case. So the respondents, in other words the proprietor of the earlier mark, the Pepperdew trademark, said it's fairly simple. Pepper and, as they described, a single rounded pepper and stalk device are the two distinctive features of the trademark, and the appellant copied both of those. Sort of makes sense. The marks are to an extent similar. I realize the colors and the fonts are not identical, but there's something to be said for this argument, and it's on this basis that they were successful before the first two lower courts. What did the appellant say? Said, no, it's the other way around. The respondents are trying to claim a monopoly in pepper, and this is South Africa. Everybody knows pepper is pepper. Plus, there are various other traders using marks incorporating pepper, like picker pepper and pepper melt, in relation to the same goods. And the court said, yes, pepper is indeed an adaptation of pepper, describes the product. The distinctive element in the mark Pepperdew is actually the word dew. If you think about it, I suppose that is correct. And the two marks are visually, phonetically, and conceptually dissimilar. Now, you may not agree with this, but it can slide by. It's probably correct, but that is the outcome. So the previous rulings were overturned. The next case was the Morris case. And if you're not confused by the names of the parties, then you also have a difficulty. So it's Morris Material Handling Limited versus Morris Material Handling SA Pty Limited. The first party is a UK company. The second one, obviously, a local South African entity. It also it related to an application for cancellation. The UK company owned registered trademarks in South Africa dating back some years. The local company tried to register Morris, and it relates to cranes and parts for cranes, and could not register the mark because of the existence of the earlier mark owned by the UK company. So an application was brought to expunge the earlier marks from the register based on non-use. As you may know, if a trademark has been on the register for more than 5 years, during which time the proprietor or somebody licensed by the proprietor has not made any use of the mark in the course of trade, anybody may apply for the mark to be removed. So that's what happened here. What made this case interesting is that there has been use of the mark, and the respondent accepted that. The only question was that used by the proprietor? Now the facts are a bit convoluted. I'm going to try and simplify it, but there's a South African company called Cone Cranes Pty Limited that was established in 2013, that was right in the middle of the 5-year period, specifically locally in Johannesburg, specifically to import and supply locally Morris parts, together with a variety of other brands in the Cone Cranes stable. I refer to the Cone Cranes stable because the South African company, Cone Cranes Pty Limited, was a subsidiary of a Finnish company, Cranes Oy, which again is the holding company of the UK company that owned the marks, Morris Material Handling Limited. So Cranes South Africa is basically a sister company or related company as the trademark proprietor. So what did the court say? The court said, but you gave me no information relating to the relationship of the various companies in the group. The only piece of information in the affidavit is a statement by the deponent, the MD of the UK company, saying that through an internal arrangement, Cranes is authorised to distribute the appellant's Morris goods in South Africa. Now, one would think that that should be enough. The requirements in terms of our Trademarks Act for permitted use are certainly not formal and not onerous. There's no need for any written agreement to be in place. It's really the trademark proprietor must permit the user to use the mark, and then that will count as use by the proprietor itself. So the court said, but these vague statements are wholly insufficient. They want more detail. While this case is also interesting, just last year we received a judgment from the SCA in the Just matter, which said exactly the opposite. There we had evidence from both the MD of the German holding company and the MD of the local South African subsidiary saying there was never a license in place between the two of us. The court said, thank you for saying that. I'm telling you, if there's a subsidiary parent company relationship, there is a license in place. So that's exactly the opposite, and the court said insufficient information. The evidence I would like to have seen is, I want to see formal agreements, because companies of any significant size would normally have written agreements. I'm not sure whether that is the case. Otherwise, minutes of meetings of the directors to where the decisions were made that a specific, the related company is allowed to make use of the trademark, or at least in emails or letters confirming this. And I saw no evidence in this case that an arrangement was actually in place. And you were challenged by the local Morris to provide the detailed information, and you failed to do so, so the trademarks were indeed removed. Right, the last case is the Primark case. That's the most recent one, was handed down last month. And I'm sure many of you would know the Primark brand, the shops overseas. Many of you may not know it. But the question was, when does a trademark qualify as a well-known trademark? In this case, Truworths applied to register the trademark Primark, could not get registration because the Irish company, which has shops in, I think, 54 countries all over the world, owns registrations, although they never had any business presence in South Africa for the identical mark, and applied for the expungement of Primark's trademark on the basis of non-use. So there is a defence in our Trademarks Act. Section 27.5 says that if your trademark qualifies as a well-known mark, it's immune to be expunged on the basis of non-use, and that was the main issue at stake in this case. So it was an application for cancellation of a registered trademark based on non-use. So in the High Court, the judge found in favour of Primark and said no doubt the mark qualifies as a well-known mark, and Truworths appealed to the SCA. So just by way of summary, there was a lot of additional evidence that Primark presented, but just to give you an idea of what the evidence included. Firstly, Primark has an annual has had a turnover in that relevant period of more than £15 billion. That's 300 billion rand. It's quite a massive amount. So internationally, huge company trading in a number of countries. I think they have 268 outlets in Europe alone. Not in South Africa. They opened in the United States in 2015 only. I think their first store was in Boston, but they are rapidly expanding, although they couldn't say for sure when they want to open a store in South Africa, if ever. Secondly, Primark has a huge social media presence, including South African internet users, running into tens of thousands. South Africans visiting all their platforms on a regular basis. Then we had interesting evidence of tax refunds claimed by South African visitors buying goods at Primark, claiming back the tax. And that equated to more than 9 million rands worth of goods purchased during the 5-year period, so it's not insignificant. And then, interestingly enough, Truworths conducted a survey. And the survey indicated that 3.5%, the survey evidence was criticised by the court quite significantly, but the outcome of the survey was that 3.5% of the people interviewed recognised Primark. Now, if you extrapolate that to the population of South Africa, that means more than 2 million people would be aware of Primark. So, now the court must apply the test to determine whether Primark qualifies as a well-known trademark. And as you may know, the test was laid down in the McDonald's case in the 1990s. And in McDonald's, it was said that a mark will be regarded as being well-known if it is known to a substantial number of persons interested in the goods or services. And substantial was again defined as not being negligible. So this was exactly the same test for common law passing off. You must prove a reputation, basically, not the majority of consumers, not a certain percentage. The argument was made that you must be as well known as McDonald's, which is really silly, nonsensical. But in the face of all the evidence, the court said the evidence is wholly insufficient. So despite all the, just go back one slide, there's an important aspect, the last bit of evidence at the bottom. So there was also direct evidence from, I think, 11 different fashion buyers of different clothing retailers in South Africa who said, no doubt Primark is a fashion leader, and all the buyers study what they do. They visit Primark, they buy sample clothing, so they all know about it. So the court said that is very impressive evidence, but it's not relevant. The court wanted to see evidence of people interested in opening Primark outlets in South Africa, because that is what happened in McDonald's. You may remember in that case, a lot of South African businessmen expressed an interest of opening McDonald's franchises, and that was accepted as valid evidence of the renown of the McDonald's trademark. So in this case, the court said, thank you for that evidence, but it's very impressive, but we're not really paying too much attention to it, and ordered the trademarks to be cancelled. Another interesting aspect of the case was, during the case, it became clear that Truworths was not honest about its adoption of the Primark trademark. In fact, during the hearing, the court referred to the deponent, perhaps a bit unfairly, as being a liar. They denied ever having known of Primark, but they attended award ceremonies, and in later affidavits they said no, they've been studying for. So it's been a bit of a lot of smoke and mirrors happening, and there's a minority judgment at the end of the SCA judgment by Judge Willis saying that he doesn't like what happened here, and he feels it difficult to condone Truworths' conduct, but as the law stands, he cannot help Primark. So unless the law is changed, he must agree with the majority view, and the marks must be expunged. So the matter is, we've applied for leave to appeal to the Constitutional Court, but whether we'll get there, we don't know. We try to dress it up as a very important matter on all levels, and we'll see if the Constitutional Court fights. But at the moment, this case leaves proprietors in a very difficult position. It will be very difficult to prove that a trademark is well known. Comment is made in the judgment that on the evidence, even Marks & Spencer would not qualify as a well-known trademark in South Africa. Marks & Spencer, incidentally, in the survey reached a 7%, I think it was 7.4% recognition rate compared to Primark of 3.5%. So it was almost double the people. According to that survey, about 4 million South Africans would know about Marks & Spencer, and the court's view was that is wholly inadequate. So no protection available, and the marks were expunged.
Okay, Gerard, let's leave it there. I just want to we have two questions on Slido that have been posted by, the first one is from Natasha from West University. Natasha, where are you? Okay, there she is. And she wants to know, is the lifespan of trademarks becoming too long given the pace of developing new brands of products and rate at which we discontinue them? And then I think she's saying that the application process outlives the brand.
There were not enough characters. Yeah.
Natasha, I think it depends on the nature of the trademark. I think you have some trademarks that you can see have been around for hundreds of years, and they probably will be around for hundreds of years. But circumstances do change, and technology sort of is happening faster than we can keep up. Let me sort of, I'm trying to think of an example, but I think that appropriate trademarks, strong trademarks, will always have longevity, and they should last forever. But of course, you must guard them, you must protect them against dilution. So it also depends on how the proprietor treats their pets. They must look after them.
Can I add a little follow-up in there that I can put in? Is obviously you'll have your house brand that protects everything and all of that.
Yes.
But if you have projects that are ongoing and they end, how would you suggest we protect it that it's by the time the application process happens, we want to say that we were associated with that particular project as the university or whatever it is, and we can't, the process takes too long to get protection?
There are two considerations. The one is how long is the project going to last? If it's going to be less than 2 years, then I would say don't bother. And also it's a cost thing. Just bear in mind, sometimes projects are seen as a test or just something, a novelty, and it turns out to be a massive success.
Yeah.
And I can mention an example, a flying fish. You all would know the flavoured beer was seen as just it was going to be a temporary product, going to be run for a few weeks, and it became one of the most successful and best grown products of SAB. Fortunately, they did apply in case it becomes a success. So it's difficult to predict, but if you know for a fact it's going to be a temporary initiative, depending on the duration of the initiative, I don't think you should bother too much. But it's more often than not, it's a cost issue.
Thanks, Gerard. Just one more. I believe that is actually from Maureen, my co-host. We have received a considerable request for disclaimers on the basis that they are common and register. How do you think we can challenge this request?
I know that the registrar has, or the registry has a policy in place where if the same element appears more than 3 times in a certain class, she's going to call for a disclaimer. And they're not very flexible at the moment, but I think it's worth a try under appropriate circumstances to try and either not get the disclaimer or to convert it rather into an admission. Then at least you can prevent others from using it as a trademark. I know also that historically, if an element appeared so often in a specific class, you didn't bother to call for a disclaimer, and I think that makes sense. I mean, you always have certain provisions of the Trademarks Act that you can rely on if use is made bona fide, in a bona fide way, descriptively or otherwise. But I would say that if possible, just convince the registry that they must rather accept an admission in the face of a disclaimer. But that's easier said than done. I think that also depending on the circumstances.
Okay, thank you, Gerard. Let's leave it there. A round of applause for Gerard. Okay, now we'll have a 10-minute period to move between rooms. So what should be happening now is rapid prototyping in patents, which is on my right. Here we'll have the digital disruption on global sports industry with Calvin Watt. And then in the room on my left, we'll have M&A, AI-driven due diligence. So if you're keen on attending the talks in the other rooms, you're welcome.